Good afternoon and welcome to GMA's Affordable Care Act Training Session 1, Waiting Periods and Eligibility for Coverage and Determining Applicable Large Employer Status. We're glad you're with us today, and I wanted to first introduce myself. I'm Allison Earls, Associate General Counsel for GMA, and I have with me Patrick Lale, an attorney with Ellerby Thompson. That is the GERMA helpline, and I'd like to turn it over briefly to Corey Dickens for to go over some technical matters.
Good afternoon. All participants are in listen-only mode this afternoon. We do, however, encourage you to ask questions. You can do that by going over to the GoToWebinar control panel on the right side of your screen. Within that control panel, you'll see a questions dialog box. If you will, please type your questions there, and please refer to the slide you're asking the question about, and we will answer those questions at the end of the presentation.
Thanks, Corey. And if you have any technical problems getting the webinar to work, please feel free to call Peter Johnny in our IT department. His number is 678-686-6266. Again, that's 678-686-6266. I also encourage you to be bold with your questions. The only people who will see the questions are the presenter, and we certainly won't identify anybody. Questions really help us, and your question may really help another person who's on the call. So please do type in some of those questions that you have, and we'll be sure to get to them at the end. Well, Patrick and I are lawyers, so we have to start off our program with a disclaimer. This ACA training session contains general information about certain provisions of the Affordable Care Act and is not legal advice. It is also tailored only for employers that offer the GMEBS health plan. So it's important to know that this material is designed for employers that are offering the GMEBS health plan. GMA offers 4 sessions of Affordable Care Act training. This is session 1, Waiting Period Rules. How to determine applicable large employer ALE status. This session is very important for all employers offering the GMEBS health plan to review. Next is session 2, the pay or play penalty rules. This is for ALEs only. Session 3, the minimum essential coverage reporting, 6055 reporting on the 1094 and 1095B forms, is for small employers. Lastly, session 4, pay or play penalty and minimum essential coverage reporting requirements. 6056 reporting on the 1094 and 1095C forms is for ALEs only. All training sessions are posted on our website, www.gmanet.com, under Services, Life and Health, More Info.
This slide is about the Affordable Care Act, kind of the big picture. And part of the goal of the Affordable Care Act was broadly to decrease government spending on health care. And that was through a lot of different mechanisms, one of which was another goal of the Act, which is to expand coverage. And you'll see some of those, the ways of doing that in the bottom bullet point, but addressing that second bullet point, there are minimum standards under the law for health coverage, no pre-existing conditions, no waiting periods longer than 90 days, some of which we'll address today in section A of this session, and also having to do with lifetime and annual limits and certain other things that we'll address in some way in either this session or session 2 on Thursday. But in terms of expanding coverage, there are a couple of different ways that ACA contemplated expanding coverage. One is through an expansion of Medicaid eligibility, and as some of you may remember from the Supreme Court case a couple of years ago, the Supreme Court kind of threw a curve that nobody was expecting by saying that, well, this is a states' rights issue, so each state gets to decide about expanding Medicaid. Some states decided to go ahead with that expansion, and other states, including Georgia, decided not to. So that expansion of coverage worked to a certain extent, but not as originally contemplated by Congress. The second expansion is that there's now an individual mandate, or a requirement that individuals have health insurance coverage, or they have to pay an individual penalty. And that goes into effect beginning this tax year. So at the end of the year, when you file your 2014 return, you'll have to show proof that you've had coverage. And then the third, and this is what we're getting into mainly in these sessions 1 and 2 this week, have to do with employer coverage. And the gist of that is that a large employer of 50 or more employees, including full-time equivalents, must offer certain minimum health coverage to substantially all full-time employees, or they face penalties. And we'll address those penalties a little bit more in session 2. Today we're going to focus in part B of this presentation on whether you are a large employer and how to count employees for purposes of that determination. So today, again, we've got 2 parts. Part A, Allison is going to handle because it deals mainly with eligibility and waiting periods under the GMEBS health plan specifically, and the new GMEBS declaration page. And again, she's going to go through some of the details applicable to your plan. So whether you're a large employer under ACA or not, this is information that you need to know if you are a participating employer in the GMEBS health plan. Part B is something to help each city determine if it is a large employer under ACA. And as we kind of joke there, it's counting to 50 using government and ACA definitions and math. So it's not necessarily intuitive, but we will go through with you the special counting rules that apply in reaching that determination.
So we're on Part A, following the GMEBS health plan eligibility rules and waiting periods in your GMEBS declaration page. So the waiting period part of the ACA says health plans may not have a waiting period that lasts longer than 90 days. There was final guidance issued earlier this year, and it clarified that it is okay to have substantive eligibility requirements that aren't based just on the passage of time. So, for example, it's okay for a plan to say there's no coverage for short-term workers, no coverage for variable hour workers, no coverage for part-time workers, or no coverage for seasonal workers, that those kind of rules may cause all sorts of penalties under another section of the law, but it will not cause any problems under the waiting period rule. The GMEBS health plan has waiting periods and substantive eligibility requirements, and they are stated on each city's declaration page. That declaration page is a maybe 2-page document that where the city officially decides who it's going to offer coverage to and what the waiting period is. There's a penalty of $100 per day per person affected for violating the waiting period rule. So what have we done so far? Well, we have confirmed that effective for 2014, all participating employers had compliant waiting periods on their declaration pages. So we know here that the declaration pages are correct. We can't know whether everybody's actually administering them properly. We hope so. In June of this year, we sent out a memorandum reminding all participating employers of their obligation to follow the eligibility rules and the waiting period limits. And we also gave everyone a heads up that there would be changes to the participation documents coming down the pipe. Then, per board action on June 22nd, a new declaration page language was approved, and a new participation agreement and trust agreement revisions were made to those documents that reflect the waiting period rules and eligibility language that must be adopted by all participating employers. The revised deck page and participation agreement protects the GMEBS Life and Health Trust from penalties. As I said, we know for sure what it says on the declaration page, but we can't control what each employer does. So basically, in those documents, the participating employer certifies it will not impose eligibility conditions or waiting periods except as written in the declaration page, and you will promptly notify us if you make any mistakes. Any penalties that arise from improper actions of the participating employer are the responsibility of the participating employer and not the trust. And that protects the trust assets. So what are a participating employer's duties? Well, first, as always, has always been the case, an employer has to determine who is eligible to be in the GMEBS health plan. You also have to provide required enrollment information to eligible employees right away. And you have to send enrollment forms to GMA, which is the program administrator for the plan, preferably 30 days before the enrollment date, if possible, so ID cards can be issued when the coverage starts. So this describes a little bit of the difference between the old declaration page and the revised declaration page. In the old declaration page, it only had two types of employees who could be covered as active employees. Regular full-time employees was the term, and also elected or appointed members of governing authorities. The revised declaration page now calls the first category GMEBS Regular Employees, and it still has the option of providing coverage to elected or appointed members of a governing authority, and there's a new category. So starting 1/1/2015, individuals that are identified by an applicable large employer as meeting the definition of a full-time employee under ACA, but who don't meet the definition of a GMEBS regular employee, can now be offered coverage under the plan. So our goal was to, as much as possible, keep everything the same for small employers. If you're a small employer, things are going to be pretty much business as usual. But if you're a large employer, you're going to have the flexibility to determine how you want to handle things, and you will be able to enroll any of these full-time employees who used to be excluded in the plan. So what is a GMEBS regular employee? And this should be something that's familiar to everyone. It's been in place for a long time. A regular employee is one who resides in the United States and is employed by the employer in a salaried or hourly position, and the position requires 30 hours of service per week or more and is expected to last at least 48 weeks. When we use the term hour of service, that's an hour for which the employee is paid or entitled to payment. So it's important to note that eligibility as a GMEBS regular employee depends on the expected requirements of the position at the time of hire. So you might ask yourself, is this employee expected to work 30 or more hours per week in a position that will last at least 48 weeks? If so, that person is eligible for the plan. It may be that your job descriptions or other documents don't include the exact hours of work. You might want to consider clarifying that in your job descriptions. Patrick, are there, I think we might have talked about this before, but are hours always included in job descriptions?
Often they are not, and for purposes of establishing whether somebody is expected to work X number of hours per week, this is something that could go in the job description or it could go in some other document. But I guess for purposes of determining eligibility as a GMEBS regular employee, there are all kinds of documents that could be looked at, so we're not necessarily recommending that people put the hours in the job description, but it might be good that it be in writing somewhere.
Thanks, Patrick. So here are some examples of people who are not considered GMEBS regular employees. These are the people who you have traditionally not offered GMEBS coverage to. When they're in a position that requires less than 30 hours of service per week. When they're in a one-time short-term position, for example, a 6-month internship. When they're in an annual short-term position, for example, a lifeguard that works every year just for the summer and then comes back every year. People who are in positions where the hours go above and below 30 hours of service per week, where you're not really sure whether, and you really don't, you really can't quantify whether the person is working 30 hours, is expected to work 30 hours of service per week. Small employers must continue to deny these employees coverage because they don't meet the definition of a GMEBS regular employee. That's why it's important to know whether you're a large employer or a small employer. If you're small, you can't offer these people coverage, but if you're large and you determine that they are ACA full-time employees, then you can. As I said before, for large employers only, there's this new category, and I like to call them ACA Mandate Employees. These are employees who don't meet the definition of a GMEBS Regular Employee, but who do meet the definition of an ACA Full-Time Employee. And as we talk about in Training Session 2, an applicable large employer must enroll ACA, not enroll, sorry, we need to change that, must offer coverage to, I'm going to change that before we send this out, offer coverage. Okay, the applicable large employer must offer coverage to all ACA mandate employees in order to avoid pay or play penalties. They don't all actually have to enroll, but they must be offered coverage. Lost my, here it is. Okay. So this dinosaur egg is supposed to show you the difference between this big circle is everybody who's allowed to be in the plan if you're an applicable large employer. First, in the big blue circle are all the GMEBS regular employees, U.S. residents in positions requiring 30 or more hours, expected to work 48 weeks. Then there are different types of other employees that are ACA mandate employees. They're not eligible as regular employees, but they are ACA full-time employees. And they might be some of those short-term positions, and well, you know, there are other examples, but it's for purposes of this conversation today, this is just an overview. There's more information in Session 2. So the waiting periods, in your declaration page, there is a waiting period of either 0, 30, or 60 days of continuous active service in an eligible position. The waiting period starts from the date the individual is hired into the eligible position or takes office. And if enrolled, the coverage starts the first day of the month coinciding with or following the last day of the waiting period. One thing that's new in our declaration page, we never addressed rehires before, but we are clarifying now that if you rehire somebody and there isn't a 13-week or longer break in service, you can't make them complete a second waiting period. And there are also some special rules for ALEs that has to do with look-back periods, and we'll discuss that next time. So watch out for some of these pitfalls. If you have positions that require an employee to complete a probationary period, it's important to remember the waiting period starts when you hire them into the eligible position. Even if you're calling it a probationary period, you have to start the waiting period with the date of hire. Be very careful of delaying when you provide enrollment information. And also be careful if there's lack of clarity about whether the position requires 30 or more hours of service per week or whether it's intended to last for 48 weeks. It's advisable to really look through your employee population and make sure that you know which ones are eligible and which ones are not based on the position. As I said before, employers that offer the GMA property and liability insurance, GRMA, may wish to contact the GRMA helpline for legal advice. Now, the legal advice would be about whether the position requires a certain amount or, you know, what kind of probationary period, not necessarily about the GMEBS health plan, but some of those employment issues you can definitely raise with GRMA helpline. So we know that everybody makes mistakes and there may be problems. The important thing is that you be aware that employers are not allowed to deny coverage to someone who is eligible based on the eligibility rules, and you may not impose a waiting period that's longer than those that are on the declaration page. If you find out that there's a mistake or a problem about enrollment, contact GMA right away and we'll work together to resolve the issue.
Now we're going to move into Part B of this session, which has to do with determining large employer status. And for some of you who may have done some reading or attended other seminars that deal with ACA, you may have heard about terms like measurement period, stability period, administrative period. Those are ACA concepts, but those deal with whether someone is an eligible full-time employee. Those are not part of what we're going to talk about today. That's part of what we'll deal with in session 2. Today we're looking only at the rules affecting how you count employees for purposes of the employer status as a large employer. So who is an applicable large employer? It's any employer who averaged 50 or more full-time employees plus full-time equivalents during the preceding calendar year. So for 2015, there's a transition assistance rule that says instead of using the whole calendar year of 2014 to measure the number of employees you have, you can use a 6 consecutive month period from 2014. But starting with 2016, you'll look back to an entire preceding calendar year. The rule has to do with, as we'll address a little bit later, has to do with adding full-time employees and full-time equivalents. And if you equal 50, you're a large employer. And if you're above 50, you're a large employer. So if you end up with right at the number 50, you're still a large employer under these rules. Why does large employer status matter? Well, there are 2 big reasons. On the left side of the screen, you see that there's mention of pay or play penalties. Again, we're going to discuss how those penalties work and how they're calculated in more detail in session 2 on Thursday. But as a general proposition, some of these penalties can be large, up to $2,000 times the number of full-time employees in your workforce. And there's some math involved, so it's not exactly that simple. You see up there minus 30. Again, we'll talk about those details, but if you can just imagine if you've got 100 employees times 2,000, even if it's minus 30, that's 140,000 in penalties potentially. So the penalties, and that's only one of the kinds of penalties, but we'll address that in more detail in session 2. On the right side of the page, you'll see that there are reporting obligations that apply to large employers. And these reports are made to both the IRS and to each individual employee. The reason is the IRS is the agency entrusted with determining whether penalties apply. And to determine if those penalties apply, they need information from both you as the employer and also from your employees. And as they take and reconcile that information, they determine if certain requirements are met for purposes of assessing a penalty. So who might be subject to a penalty? Again, this is an overview. We'll get into this in a little more detail in session 2, but it shows the importance of why we're covering what we're covering in this session. You can be subject to penalties if 3 things happen. And the first graphic on the bottom left there with the time clock, first, it's got to be an ACA full-time employee, somebody who works or is entitled to be paid for 30 or more hours per week. That's a full-time employee. In the second graphic in the middle there where somebody's got the shopping cart, the full-time employee has to go out onto the insurance exchange and has to buy his or her coverage on the insurance exchange. That's the second requirement. The third requirement for the imposition of a penalty is that the individual who is a full-time employee and who has bought insurance on the exchange gets a subsidy. The subsidy is only available to people based on their household earnings. So even if somebody's a full-time employee and they go onto the exchange, they can only qualify for the subsidy if they meet certain income requirements that are set forth in ACA and that we deal with a little bit in session 2. So those are all the things that have to happen for you as an employer to have to pay a penalty under ACA. And again, as I mentioned previously, and we'll deal with in session 2, large employers have to do this 6056 reporting. 6056 is a section of the Act that talks about the requirement to provide this information. And in the second session, we go through in some detail what is included in that documentation. As a heads up, this is, again, this session and this Part B have to do with whether a city is a large employer, and we'll get into in Session 2 some of the details about the pay-or-play penalties and the reporting.
Okay, so who is an applicable large employer? Well, the definition is an employer who averaged 50 or more full-time employees plus full-time equivalents during the entire preceding calendar year. But for 2015, you can use 6 consecutive months in 2014 instead of the full year. There are a number of steps. So step 1 would be identifying all employees using the ACA definition of an employee. Then you would want to identify which employees can you just carve out and not even bother looking at their hours. Then you want to determine what time frame you're going to use for counting up their hours, so which 6 consecutive month period, for example. Then you'll want to count the hours for all of the employees you found. Then you would count up which ones are full-time employees. Then you count the full-time equivalents using ACA math. And if the total of full-time employees plus full-time equivalents is 50 or more, then you want to apply what's called the seasonal worker rule to see if maybe the only reason you're above that amount is because of some seasonal workers. So when you're identifying all the employees you have to take a broad look, and remember that the ACA requires you to look at everyone who's in the same controlled group. So 2 employers are part of a controlled group if at least 80% of their interests are held by one or more common owners, or if a significant percentage of one entity's business is to perform management services for another entity. The regulations say that governmental entities may apply a reasonable good faith interpretation as to whether they're part of a controlled group. And my image over here on the right is 2 groups of people working technically for the same employer because of these control group rules. So you may want to ask, does our city control an authority? Consult with your city attorney or with the GMEBS helpline if you're a GMEBS employer to determine whether you and the authority should each count each other's employees when determining ALE status. Some things to consider when you're making this reasonable determination. Do you have separate boards, separate tax IDs? Have you consistently treated the city and the authority as separate entities for employee benefits purposes? The goal is that when you're making a good faith decision is to document some of your reasons and show that you actually thought about it and came to a reasonable conclusion. The next thing is identifying all workers who receive pay from the city. I do have here paid directly from the city. You also will want to look at all workers who are paid indirectly, say through staffing agency arrangements. But you want to determine which of these paid workers are common law employees. And the key definition for common law employees is the employer has the right to control the manner and means of the individual's work. And there's a Social Security there's a test on the Social Security website that helps you determine whether somebody is your common law employee. Patrick, what should an employer do if they're not sure whether one of their workers is a common law employee?
Well, this may be where you want to consult with your city attorney or contact the GMEBS helpline to really assess, again, that there is kind of a broader test, but I think controlling the manner and means of an individual's work is kind of the key component. And as an example of that, if a small city that does not have its own IT staff says, gee, we need to upgrade our whole IT system, you hire somebody to do that, you say, we're going to pay you X thousand dollars to do this work, we don't know anything about computers, so you're going to have to decide how it's done, but this is the end product we want. Chances are that's truly an independent contractor, and the people that work for that outside computer company are not your common law employees. On the other hand, if you hire somebody that you call an independent contractor, and you say, we want you to do code enforcement X hours per week, and we're going to pay you by the hour, and we're going to tell you when to show up to work. We're going to tell you what to wear. We're going to tell you what part of the city to go to do code enforcement. You're much closer to controlling the manner and means of that individual's employment. So even though you're calling them a contractor, they may be found to be a common law employee, meaning that they would count for purposes of the Affordable Care Act. Okay. Looking at common law employees broadly, again, these just give some other examples of elected and appointed officials, some short-term employees, employees who work for another employer, and sometimes you see this in jurisdictions where maybe your police officers work for the city during the day and maybe a full-time during the week, but they also pull shifts working for the sheriff's department on the weekend or at nights or something like that. Sometimes those folks may be counted by both agencies. Staffing agency workers can also be counted. Other common law employee examples, I think we've got staffing agency up there again. There's going to be, we have been told, additional guidance coming out on staffing agency employees and how to count them and who should count them. We've gotten final regulation guidance on a lot of the issues that we're talking about in session 1 and 2, but staffing agency workers and their status is something that has been, we've been told there's going to be additional guidance issued, so we don't, this is not final guidance that we have on that particular concept. But I think the broad idea to think about in this step 1 of identifying all potential employees is you want to consider anybody who might be your common law employee, and these subsequent steps will narrow down who you might be able to exclude. But I think as we start, the broad idea is that you want to think broadly and get as many people in the possible circle as you can, and then start weeding them out based on the subsequent steps that we'll review.
Thanks, Patrick. The one thing that it may be very helpful to do is, as I said, checking the contract on your staffing agency, because there may be people who you hire and you really, you do absolutely control exactly what they do, and it is really important to be on the same page with the staffing agency. Especially, you may want to make sure that the staffing agency is providing them health insurance. That's one important area. Thanks. So once you've identified all of your common law employees, we can now look at which employees can be excluded. You do not have to count the hours worked as a bona fide volunteer. So a bona fide volunteer is any volunteer who is an employee of a government entity, but whose only compensation is in the form of expense reimbursements or allowance, or reasonable benefits including length of service awards, or nominal fees customarily paid by similar entities. We know for sure that volunteer firefighters, volunteer EMTs, volunteer coaches, people that maybe get a dollar amount every time they come, but are not on a regular salary and are not regular hourly workers. These may be excluded when you're counting hours of service. You also don't have to count hours of service for student employees who are paid or entitled to payment through the federal work-study program or a state or local government's equivalent. So you're controlling their work, they are your common law employee, but they are getting paid through a federal work-study program or equivalent. If they don't meet that definition, their hours of service must be counted. So the next thing to do is choose the time frame that you're going to use for counting hours.
And again, there's a special rule for 2015 that you can look at any 6 consecutive month period in 2014, but the general rule and the rule that will apply starting with the 2016 year is that you'll determine whether you're a large employer based on your full-time employee count through the calendar year 2015 or the preceding calendar year. Step 4 of the process we've outlined is to count the hours of service for employees who are not excluded. So it's important to understand what an hour of service is under the Affordable Care Act. And it's any hour for which an employee is paid or is entitled to payment. Those cities who are listening in who are covered by the FMLA may know that for eligibility purposes under the FMLA, one of the things you look at is whether an employee has worked 1,250 hours in the preceding 12-month period to be eligible for leave. That is an hours worked requirement, doesn't include hours paid, PTO, and that kind of stuff. This is a broader definition under ACA. So it's the hours actually worked or paid or entitled to be paid. So for hourly employees in that second bullet point, we identify, PTO does count. We've also got to note that if you use a payroll service, you may ask your payroll service to help you determine the number of hours for each particular employee. For non-hourly employees, there are a couple of different methods you can use. You can count the actual hours somebody works. You can use a day's worked equivalency of 8 hours per day or a week's worked equivalency of 40 hours per week. We've got an asterisk on that day's worked equivalency. You can't use that method if it would substantially understate an individual's hours of service. And if you think about police who may work 12-hour shifts or firefighters who may work 24-hour shifts, obviously a day's worked equivalency would not be appropriate in that circumstance. And just as an illustration, this next slide shows that Mary is a salaried employee who is expected to work 10 hours per day, 3 days per week. She works a little more than that, so her actual hour method comes up with an average of 32 hours worked per week. The week's worked equivalency would be 40 hours per week. Either of those would be fine, but under the days worked equivalency, she would only have 24 because it's using an 8-hour average times the number of days she works per week. And so the days worked method is not appropriate because it would substantially understate her hours and cause her to be treated as something less than a full-time employee. So now that we understand what ACA means by counting hours worked, let's go to step 5 and count full-time employees. And you see there again our familiar worker who's clocking in and working at least 30, maybe more. And for large employer status, a full-time employee is somebody who works or is credited with 30 or more hours of service during a week or 130 hours of service per month. So if somebody works exactly 30 hours per week, that person is counted as one employee for the large employer determination. If a different employee in the same position works 48 hours per week, that person is also just one employee. If you're 30 or more, you're only going to be counted as one employee. The person who works 48 hours a week is not 1 point something employees. The most you can be is one. So for these full-timers that work 30 more hours a week, each employee is counted as one. In contrast, under step 6, when you count full-time equivalents, you kind of use a different method where you are engaging in some decimal math. So you essentially take the total hours of service in the month for employees who are not full-time. We note there that you can't count more than 120 hours of service in a month per employee, and you divide that by 120 to get the number of full-time equivalents. Remember, the rule is you're a large employer if you have 50 full-time employees plus full-time equivalents. So we've got our familiar image of folks clocking in and working. The first worker, 110 hours in a month, the second 115, the third 110. The fourth worker there in the bottom left corner has worked 122, but we can only count 120 of those hours in a month because of the way ACA is designed. And the last worker works 98 hours. And over in the right, you see the formula for the hours of service in the month of July, adding up all the hours that they've worked except that for that fourth worker, you only count the 120. So you end up with 553 hours divided by 120 for the month, and that's 4.6 FTEs. So you've got in step 6 your count of full-time employees. This is your decimal using count of full-time equivalents, and if the combination of those two adds up to more than 50, then you've got large employer status.
So what happens if you add up the full-time employees and the full-time equivalents and you have 50 or more? Well, try the special rule for seasonal workers. There's this special rule that says that if you have 50 or more full-time employees and full-time equivalents for no more than 4 calendar months or 120 days, and if all the employees in excess of 50 are seasonal workers, then the employer is not an applicable large employer. So first, what is a seasonal worker? A seasonal worker, one solid definition for it is that a seasonal worker works in a position that customarily lasts 6 months or less and works in a position that begins each year at approximately the same part of the year. Guidance is clear that lifeguards, summer parks and recreational staff can be seasonal employees or seasonal workers. We welcome questions. We will be developing FAQs. If you have other types of workers that you think might be considered seasonal workers, please do send them to us and we can look at those different categories and provide an FAQ. But for sure, these lifeguards, summer parks and recreational staff would be seasonal workers. So here's an example of an employer that has determined that it does want to try this special rule. So for January through April, the employer had 48 full-time employees and full-time equivalents and no seasonal workers. But from May through August, the number jumps way up to 82 because there are 34 full-time lifeguards, pool workers, park maintenance workers that are hired for the summer season. Then back in September through December, it goes down to 48 again with no seasonal workers. So it's true that they only are above the 50 amount because of those seasonal workers, and since this occurs for no more than 4 months, the employer is not an applicable large employer. There is a transitional rule for ALEs with less than 100 full-time employees and full-time employee equivalents. Under this transitional rule, the ALE will qualify for a 1-year delay in pay or play penalties if the employer maintains their workforce size and position hours from February 9th, 2014 to January 1st, 2015, maintains the same health coverage from February 9th, 2014 to January 1st, 2015, and certifies above in a special 6056 report. The pay or play penalty rules will then become applicable for 2016 coverage instead of 2015 coverage. Remember, even ALEs who qualify for this 1-year delay in pay or play penalty rules still have to comply with the 6056 reporting rules. That means they will still need to complete a form with the IRS and provide a statement to all employees that are full-time employees and all employees that are provided coverage. You may want to consider about whether you're going to try to adjust your personnel practices in any way or whether you're going to try to keep them stable.
And some of the questions you may have, you'll see there on the slide in the first bullet point. Are you trying to get below 50 full-time employees and full-time equivalents? Maybe reducing the hours required for a particular position below 30. These are all somewhat precarious decisions to make and should be undertaken with advice of counsel, including your city attorney. I will say that private employers who are subject to ERISA, the Employer Retirement Income Security Act, are subject to a section of ERISA 510 that would bring these kinds of employment decisions under pretty high scrutiny. If that section of ERISA says if you make an employment decision for the purpose of depriving someone of benefits, that change in employment decisions is actionable in a private lawsuit against the employer. Well, government entities are not subject to ERISA, so there's not that constraint on your decision making, but you do have charter provisions, sometimes ordinances that may set out certain requirements about making changes to various types of positions. So it may not be that you can't make those changes, but you may have to go through certain steps in making those changes. There are also issues that you may want to consider in terms of just overall fairness of who is affected by some of these changes. If, for example, all the people whose positions get changed, or a majority of them tend to be female, and males' positions are not affected, or the affected positions tend to be held by minorities, and positions held by non-minorities are not affected. Again, those are things to talk over with counsel, with your city attorney, or with outside counsel. So again, if you're unsure, consult your city attorney or other resources available to you. And as we mentioned early on in this session, if you have questions about the GMEBS plan particularly, it's probably best to contact GMA and Allison. If you've got questions on how to count employees, common law status, stuff like that, you can contact me, or your other outside attorney or your city attorney. And if you subscribe to the property and casualty coverage under GRMA and you're a member of GRMA, that call to me may even be free. So let me put up here Allison's and my contact information so you've got that available as well.
Thanks, Patrick. And I would just like to note that when you call us about GMEBS health plan, certainly we can tell you all sorts of things about eligibility, and we can provide general answers to general questions about the ACA. I would just clarify that we don't provide legal advice, but we do often answer questions that city attorneys have. And we, as I said, we are very interested in creating some frequently asked questions. So please do send those questions along. The GRMA helpline actually does provide free legal advice, as does your city attorney. So we have any new questions coming in? Okay. So there was a follow-up to one question about a person who left and then was rehired 1 month later. I would say that you would not need to impose the waiting period on that person. My fellow attorney here agrees. So if somebody leaves and comes back within 1 month later, you would not make them go through the waiting period, even if that happened now. We can certainly provide more information about the 13-week in the cover letter that goes out with the new declaration page. I believe I've answered all questions. Oh, no, there was another question about is the week, the 30 hours per week, a calendar week or a work week? This would be an employer that has an official work week of that starts on a Friday and ends on a Thursday. That is a very interesting question. I would say that I believe the original language was on business days, or referred to business days. So that might provide the answer, but I will follow up directly and look into that. Is there anything else? I think that's it. So any last questions, please send them in. Otherwise, I don't see anything else coming in. All right. Well, thanks, everyone. We will be sending this presentation to everyone who attended, and we look forward to your participation on Thursday. If you think that you might come close to being an applicable large employer, or if you just want to know more about all the things that are required of applicable large employer, please join us on Thursday at 2 o'clock. Thank you very much.
Thank you.
And thank you, Patrick.